And then on bond, nothing to add, Mr. Rolston?
The only thing I'd ask is, I would ask that Chatfield turn over their passports. Pretty standard and typical, and we'd ask that the court require that.
Okay. And that is because of a fear of non-appearance or flight?
Yeah, exactly, Judge.
Okay. I just have to say that is not at all typical in this court's practice. I mean, unless there is a specific, if there's a circumstance surrounding a particular defendant. So I would just, if you would like to elaborate on what it is about Lee Chatfield, Stephanie Chatfield, that would require the court to have them surrender their passports. I don't know.
I guess my thought is that whenever anybody's charged with, as in Mr. Chatfield's case, with conducting a criminal enterprise, that's 20-year felony, prison guidelines. It's a serious offense, and I understand what you just said about it's your practice to not require that, but typically in the cases that I handle, that's what I've seen judicial officers and many times ask the defense to turn over the passports during the pendency of the case.
Okay.
I think the short mentioned the other day that they were in Europe recently. So, up to the court, and those are my thoughts.
Okay. So it's the serious of the charge, and perhaps it sounds like the Chatfields, have the means to travel out of the country.
All correct.
Okay. Thank you. Ms. Chartier, would you like to be heard on bond?
Thank you, Your Honor. Mr. Chatfield is not a danger to the community. He has absolutely no criminal history whatsoever, and these are serious crimes, but they are financial allegations. As it relates to him being a flight risk, it has been almost 2.5 years that Mr. Chatfield has had to live under the umbrella of allegations being made. His allegations, his life have been in the media regularly. He has been wrongfully maligned. There's been speculation, rumor, innuendo, false claims. Throughout all of that, he has never fled, not once. If he were going to flee, he would have done it by now. He would not have asked the court's permission to travel out of state. He would have left. He has 5 young children. He has no history of failure to appear in court because he's never had to be in court for any sort of criminal offense. And after 2.5 years of being falsely accused, he is looking forward to his day in court and fighting this. Mr. Chatfield is not a flight risk at all. At our last hearing this week, Mr. Ralston asked that Mr. Chatfield be treated like any other defendant, and I'm asking for the same. Similarly situated defendants have been required to not post a bond, but have had a personal recognizance bond, and that's what I'm asking on behalf of Mr. Chatfield. He is ready to fight these charges, and we will fight these charges whenever we need to appear in court.
Thank you, Ms. Chartier. Mr. Newberg, would you like to be heard on bond on behalf of Stephanie Chatfield?
Thank you, Judge. Judge, Ms. Chatfield is in the same situation as Mr. Chatfield. I think I brought it to the court's attention at the last hearing. During the 2 years investigation, she was contacted, or I was contacted by law enforcement. She went and spoke with law enforcement on different matters. She always appeared. During that time, she also left the state and she also left the country, but she also, without having any requirement to do so, let me know when she was leaving and when she was returning, knowing that there was an investigation going on. That's also the same situation here, Judge. She called and let me know over the weekend that they were headed to Kentucky, that they had pre-booked a flight. And we took the step of notifying the court even before an arraignment to allow them to travel out of an abundance of caution. And here they are on time today. She has no criminal history. She is working as a teacher. She has 5 kids. And so I'm going to ask the court to give a PR bond and set this matter, which the court already has, for a preliminary examination, and we can see how the facts fared out at that point.
Thank you.
Judge, real quick,
Absolutely.
I just noted Mr. Newberg indicated that they're flying to Kentucky. I think Mr. Schmidt, that's probably a point we should clear up.
Yeah.
They drove. If I said flight, that's my fault. They drove.
Okay. Thank you. Very good. So turning first to Mr. Chatfield, both Mr. and Mrs. Chatfield, were you both able to hear what the lawyers told me in regards to bond?
Yes.
Okay, thank you. So as the parties all know, under Michigan law, the court may consider two factors in making a bond determination. Those factors are one, whether the defendant will appear for all court dates, and two, whether the defendant poses a risk to public safety. The court agrees with the defense counsel, and I don't think that there's really much objection from the Attorney General that neither factor in these cases is triggered such that any sort of money bail bond is allowed in this case. And any concerns that the court has as to either of those factors can be addressed through bond conditions. So, Mr. Chatfield, turning to you, your bond is set at $100,000 personal recognizance. That means that you do not have to pay any bail money at this time. I'm releasing you because I trust that you will come to court as directed and you will follow my bond conditions. Am I right about that?
Yes.
And then Ms. Chatfield, your bond is set at $15,000 personal recognizance. And again, I agree with your attorney that there's good reason to trust that you will come to court as directed and you will always comply with my bond conditions. Am I right about that?
Yes.
Okay, thank you. And then with that, your conditions, and this applies to both defendants, are as follows. You must appear as directed. You may not leave the state of Michigan without permission of this court. You must not commit any crime while you are on bond to this court. Given the information provided by the Attorney General, the court is ordering that Mr. and Ms. Chatfield surrender their passports to the 54B District Court, and the court will provide you instructions on how to do that and comply with that order. I wanted to address the parties. Often there is a no contact order that is ordered between co-defendants. Obviously, the circumstances of this case would make a no contact order difficult. And so I'm clear, the reason for the no contact order is to preserve the integrity of the proceedings. Mr. Rolston, do you have a position on a no contact order between the co-defendants?
No, I think that'd be very cumbersome.
Agreed. Ms. Chartier, anything on that?
A no contact order would make it incredibly difficult for them to parent and be married because they wouldn't be able to speak to one another. So we would ask that that not be imposed.
Okay, and Mr. Newberg?
Nothing additional to add,
Okay,
Judge.
so for the reasons stated by the attorneys, that will not be imposed in this matter. Ms. Chatfield and Mr. Chatfield, your bond will be overseen by the 30th Circuit Court Pretrial Services Division. The court will provide you and your attorneys with their contact number, and I'm ordering that you must contact pretrial services today, May 2nd, by the end of the business day. Mr. Chatfield, is that understood?
Yes, sir.
And Ms. Chatfield, do you understand that as well?
Yes.
Okay, thank you very much. And like I said, we'll make sure that you get the phone number instructions on how to contact pretrial services. Next, we need to address a fingerprint order. The court understands that the parties, the defendants, need to be fingerprinted because this is an attorney general case. Mr. Rolston, the court has ordered that the defendants must go to a location to be determined by the attorney general to have one of their special agents fingerprint the defendants, and has ordered that this must be done by May 10th. Any comment on that, Mr. Rolston?
Does that include the DNA, the biometric collection too, Judge?
It does not. It's just a fingerprint order.
I think the court will, let me check here, I think it also requires the DNA too.
We can address that if you wish to, but we all know that fingerprints are required. So as to the instructions to the defendants that the location will be determined by the Attorney General, is there any other instruction that the court should give the defendants?
I just, it's 104, E6 is the court rule that I'm thinking of that requires a DNA collection, but, no, nothing else to add, Judge, thank you.
Okay, very good. So, Miss Chatfield, I have your fingerprint order here. I'm signing that. So you'll have to stay in good contact with Mr. Newberg, who will help facilitate that these fingerprints get taken. This is just a standard part of every court case. And this, again, order must be complied with by May 10th. Understood?
Yes.
Okay. And same for you, Mr. Chatfield. Do you understand this order?
Yes.
Okay, very good. Thank you. So next, the court wanted to address that it has received a travel request from each defendant, and note that at a hearing of Tuesday of this week, the parties notified the court about a pre-planned trip that Mr. and Mrs. Chatfield had planned out of state. The court concluded that that trip would not impact the two factors that it may consider in making a bond determination, and instructed the defendants to complete a travel request that all defendants who appear before this court must complete and use to request permission to travel out of state. So I have received that request from both Lee and Stephanie Chatfield. Ms. Chatfield, your request states that you would like to leave the state on May 1st, returning on May 6th. And for the purpose of travel, it explains that you will be accompanying your husband to Louisville, Kentucky. A portion of the trip will be for my husband's business meetings, and the other portion will be recreational in nature. And then you provided an address where you would be staying. Ms. Chatfield, this is signed and dated, and it is noted on the form that if granted consent by the 54B District Court to leave the state of Michigan, that you agree to depart and return on the dates and times indicated above, and that you understand that failing to comply with the terms of this request could result in a violation of bond conditions. Ms. Chatfield, is all the information on this form correct?
Yes.
And you signed and dated it?
Yes.
Okay, and then you understand the consequence of not complying with the information provided, correct?
Correct.
Okay,
Yes.
and Mr. Chatfield, I received your request, which informs me that you would like to leave on those same dates, May 1st, returning May 6th, and that you would be traveling from Michigan to Louisville, Kentucky by car, and you provided an address where you would be staying, and that it tells me that you're traveling for business and recreational purposes. And Mr. Chatfield, under the information that you agree that you will depart and return on the dates and times indicated, and that you understand failing to comply with the terms could result in a bond violation, you signed and dated that. Mr. Chatfield, is this all accurate information?
Yes, it is, Your Honor.
And did you sign and date this form?
I did.
Okay. And so as to these requests, Mr. Rolston, any comment on behalf of the Attorney General?
Only that I thought the information the court received on Tuesday was pretty thin. And what I mean by that is, I mean, even, the name of the consulting firm that Mr. Chatfield and, and the exact reason for the travel, I mean, I didn't feel like there was a lot of detail given, is I guess what I'm saying. And again, I asked the court to treat him like anybody else. And the nature of the travel to me, again, the description by Ms. Chartier was, she imagines they're going to be doing a lot of things, but didn't really provide the court with a lot of detail. I mean, it sounds like they're going down to the Kentucky Derby.
I thought that was established on Tuesday also. Ms. Chartier, anything? Well, first of all, say in looking at Ms. Chatfield's request, that is a detailed enough and typical normal request. I do find that Mr. Chatfield's "I am traveling for business and recreational purposes" is more vague than the court would typically receive. And if, as the court is more is used to a request that might say, "I'm traveling for an educational conference to, this state and this date and time, and this is the professional organization." And often people would let me know if there's any kind of family emergency. Of course, they're traveling for a funeral of their grandparent and they will be going from. So I do get more detailed information. Business and recreational purposes is quite vague. Ms. Chartier.
Thank you, Your Honor. So Mr. Chatfield and Mrs. Chatfield are going to Lexington, Kentucky, in Lexington and Louisville, Kentucky. I think they pass through Lexington to get to Louisville. They will likely go to the Kentucky Derby. I think the level of specificity that Mr. Ralston is looking for doesn't exist when two adults are traveling. They probably will be going to dinner. They'll probably be going for walks. They'll likely be going to the Kentucky Derby. But is their entire day mapped out from the time they wake up to the time they end? No, they don't. And the reason why I say it's likely that they will is they have 5 young children. So if a child gets sick, they're getting in that car and coming back. If somebody else gets a cold or gets COVID, they're not going to the Kentucky Derby. So there are so many life events that come in that it is impossible to list an agenda. Mr. Chatfield runs a consulting firm. Mr. Ralston in the AG's office knows that because they've been looking at the details of his life for the last 2.5 years. He's going down there to meet with potential clients. I mean, to have to specify who they are is such an infringement on his privacy that I would absolutely, argue against that. He is going to Louisville, Kentucky for his business. They are going to also enjoy themselves while they are there. He is conducting himself in the exact same way that he has the last 2.5 years. He's had to travel for work. His wife has frequently come with him, and then they go home. This is no different than any other trip, except for the fact that now he is under a court order.
Okay, thank you. Well, I appreciate, Ms. Chartier, the additional information, and the information you provided would suffice to have this be a normal travel request that the court is accustomed to. So they are traveling. The plan is to go to the Kentucky Derby. There will, of course, be other recreational events that may happen along the way, but also that Mr. Chatfield has a consulting business, and he will be meeting with clients. I don't need to know the clients' names, of course. I don't need to know restaurants or anything, but that is helpful and, like I said, more typical a request that the court would be comfortable granting. So with that additional information, the court is granting the request. Ms. Chatfield, I'm signing your request right now and approving that, and same for you, Mr. Chatfield. So moving forward, and the court is anticipating that this may come up again, just so the parties understand, as is the court's typical practice. This is the travel request form that is used for all defendants. I think I've made clear the level of specificity that the court is accustomed to. And Mr. Ralston, certainly, if the Attorney General would like to be heard on these travel requests, particularly if they're quite frequent, the court would be inclined to just say that we will schedule a review of these travel requests. Those reviews would always be held on Zoom at the convenience of the parties, and the AG could be heard.
Thank you, Judge. We asked for that.
Okay, so that's how all the parties understand that is how we will move forward. Very good. So I think that takes us to what I see as our last order of business, which the court has a motion before it from the Attorney General's office. Mr. Ralston noted this motion that was filed on behalf of the Department of Treasury. Are the parties ready to address these motions today? Mr. Ralston, or I think it's, I want to greet you. Is it Mr. Bobas?
Yes, Your Honor.
Okay, nice to meet you. Are you ready to proceed today, sir?
Yes, Your Honor.
Okay, and Ms. Chartier, have you received and reviewed this motion, and would you like to proceed on it today?
Yes, we have received it, and yes, proceeding today is appropriate. Thank you.
And Mr. Newberg?
Yes, Judge, we've received it, we've gone over it, we're ready to proceed.
Thank you. So, Mr. Bobas, on behalf of the Department of Treasury, this is your motion. Anything you would like to state for the record?
Just briefly, to Your Honor. So last week Friday, I filed the motion brief in order for the disclosure of defendant's tax information according to MCL 205.281F. And in Michigan, taxpayer information provided to Treasury may not be released without specific statutory authorization. And 281F governs the proper release of taxpayer information, and only under limited circumstances, including a court order, can Treasury release taxpayer information. Thus, Your Honor, an order is simply needed to facilitate the exchange of documents in this case.
Thank you so much, Mr. Bobas. I appreciate that. Ms. Chartier, any objection to this motion?
No, it's my understanding, I just want to make sure I state this on the record, because for me, there was some lack of clarity in the motion that was filed. My understanding is these tax documents have already been released to the Attorney General's office. So, for example, Mr. Ralston and his team have them, and then the order just governs the release to the defense. So if that is what the motion entails and that's what the government is requesting, then we don't object to that. If it were releasing documents beyond what Mr. Ralston and his team have received, then we would be objecting to that.
Mr. Bobas.
So the order covers both documents that are currently in the possession of Mr. Ralston, but it also address future documents that may be needed to adjudicate this case. So, for example, if Mr. Ralston needed a Treasury employee to testify, this order would also cover that employee as well, Your Honor.
I noted that in the motion. Does that answer your question, Ms. Chartier?
It does to an extent. So if an employee has to come and testify as to what documents have already been disclosed, then I have no issue with that. But if it covers future documents, then I believe that should be addressed on an ongoing basis. I don't think that we should have a blanket order that whatever Mr. Ralston believes he needs from Treasury to prosecute this case, he should get, and we're agreeing to that. I think if there are additional documents, we can deal with that in another motion before the court.
Okay. Mr. Newberg, would you like to be heard on this motion?
Yeah, Judge, same comments that Ms. Chartier just made. I'm fine, as long as the order just governs documents that have already been turned over. My client is not consenting to any additional documents to be provided to the Attorney General's office from the Treasury as the investigation continues. I think one of the things that was clear when the charges were announced is that the Attorney General's office is still investigating this case. So if it's going to cover documents that are currently in the possession of the Attorney General's office and we need them as part of the discovery, great, I have no objection. If it's for additional documents, then I'd like the court to table that issue, set this for a hearing on a different day, and we can address it on a different day, just as to the documents that have not already been provided to the Attorney General's office.
Okay. Mr. Bobas or Mr. Ralston, is there a way to limit the order that's been proposed to the information, the tax information already in the possession of the Attorney General's office?
I don't represent Treasury, so I'm going to let Mr. Bobas.
You'll defer to Mr. Bobas. Okay, Mr. Bobas.
Yes, Your Honor. Certainly, we could limit the order. Again, in the interest of judicial economy, the order simply protects Treasury and its agents from criminal penalties. It's really a non-controversial order, but it is up to this court, Your Honor.
Okay. Mr. Bobas, you've heard what the defense attorneys, their concerns or their objection to the order. We can set this for a hearing and we can adjudicate this. This would, of course, be it would delay disclosure, which the court is interested in having the documents disclosed as soon as possible. So if there is a way that we could add language or strike language of this order to limit to satisfy the defendant so we could have the tax records and Treasury given the protection it needs as soon as possible. So is there a way to add, I'm looking on page 2 of the proposed order, if we all would want to look there. And it states tax-related information relevant to these proceedings. Is there a way that we could limit the tax-related information already obtained, already in the possession of the Attorney General's office related to these proceedings?
We could, Your Honor.
Okay. Ms. Chartier, would that satisfy your objection?
Yes, Your Honor, as long as it is only documents currently in the possession of the Attorney General's office, and there's certainly no waiver of future documents, that does cover our concern. Our
Okay.
concern, quite frankly, in this regard is not judicial economy, it's protecting Mr. Chatfield's rights.
Understood. Would you like to propose language, Ms. Chartier?
I think that if the Attorney General redrafts the order with some proposed language, we could take a look at that, and then that could be submitted to the court. I also don't think this really needs to hold up the items that are not tax related, that the Attorney General's office can disclose to us. They do have a protective order signed by the court. So those documents can be forthcoming, and then as we work out the language, the tax documents can follow.
Okay. Mr. Newberg, do you agree with that and would like to proceed accordingly?
Yes, Judge.
Okay. Mr. Bobas, would you be willing, please, to work with Ms. Chartier and Mr. Newberg to draft some language in the proposed order that could be agreed to, and then that would be submitted to the court at a later date?
Yes, Your Honor.
Okay. Thank you, Mr. Bobas. Anything on that, Mr. Rolston?
We're gonna be cautious about, we're not gonna turn over any discovery until this issue is resolved. Because we're gonna be cautious about, in case there was a document in a file, that, we missed and then we're in violation of the statute. So we'll wait till this issue gets resolved. I'm sure it'll be resolved very quickly between the 3 lawyers. And then we'll turn over discovery after that.
Okay, very good. So that definitely does make this a priority for the attorneys. Understood?
Yes.
Okay.
Yes, Judge.
Thank you so much. So with all that, we've accomplished a lot today. Mr. Rolston, do you have anything else for this record?
No, thank you very much, Judge. It's been a pleasure.
Thank you. Ms. Chartier, do you have anything else for this record?
I do, Your Honor, just 3 things. So for future travel requests, if there is a Zoom hearing, will Mr. Chatfield need to attend by Zoom, or will it be conducted the same way it was earlier this week with just the lawyers?
Right. So the Mr. and Mrs. Chatfield would be required to attend, and the reason is because it's their request, and of course they are in the possession of the most detailed information. They were not required to attend on Tuesday because they hadn't been arraigned by this court yet. So now they are arraigned. The case is officially started. They are parties to this case. They are fully apprised. They have met the court, and so we'll proceed, and their appearance would be required.
Thank you. And then for the passport surrendering, is there a particular date that the court would like that to be surrendered to the court by? And what I was anticipating was Mr. Chatfield will provide that to our office, and then we can turn that in.
Very good. Thank you, Ms. Chartier. Since I understand the Chatfields will be returning on May 6th, so could we have the May 7th be an appropriate?
So
Go ahead.
that is a little bit of a challenge because they live a few hours away, so they would need to go up north, get their passport, and then drive back to us. If possible, if it could be by May 10th or May 17th.
Okay, May 10th.
Okay. And then the fingerprinting through the Attorney General's office, I just would like to place on the record, I would ask Mr. Ralston to contact me so that we can facilitate that. And that way I will ensure that Mr. Chatfield gets that done. And then the other for contacting pretrial services, will that information be sent directly to me and I will forward that to Mr. Chatfield?
It will. Thank you, Ms. Chartier. You are probably familiar, but it's going to be the phone number that we use all the time in every felony case. Thank you, Ms.
And
Chartier.
then I can provide that to him now. Thank you.
Okay, perfect. Thank you. Mr. Newberg, anything further for this record?
No, Your Honor, thank you.
Okay, very good. Thank you all for your appearances today. Lee and Stephanie Chatfield, good luck to you, and we'll see you again soon. That's all for this record. Thank you.
Thank you, Your Honor.
Judge.
Have a great day.
You too.